Yeah, that's him.
That's him?
I didn't think you got to shave
Yeah,
that.
that's real quick.
Yeah.
Never mind.
Maybe it's the other guy that did it.
Yeah.
Oh, you'll be.
I got Lex.
Okay. All right. Well, it's everything. John. All right, that's him.
Yeah, that's him. He's got more brain in his beard than in that picture. Yeah, we'll do that too.
Yeah.
He's like through that window right there. He's the first thing in line. It's not a good picture.
Well, he doesn't have it.
Yeah.
All right.
Thank you. Have a seat. All right, good morning, gentlemen. I'm Judge Burns. Please understand I'm here to set your bond. I'm not here to try your case. You're here today because charges have been filed against you by the state of South Carolina. The state of South Carolina and the United States Constitution afford you constitutional rights regarding these criminal proceedings, those being the right to a trial by a jury and the right to an attorney. Understand that having the right to an attorney does not necessarily mean an attorney will be appointed for you. It simply means you have that right. If you Everyone in here today is either probation violation or bench warrant or general sessions charges. So there's no magic municipal charges, so we'll just deal with the general sessions. Because you have general sessions charges, there will be no court date set today. However, once that court date is set, it's important that you show up for it. Failure to appear for a general sessions trial date can result in a fine or imprisonment or both. An example would be if you fail to appear for a general sessions felony trial date, you could face a fine of $5,000 or imprisonment of 5 years or both. Because of general sessions charges, you are entitled to what's called a preliminary hearing. This is a hearing where the state must show that they have the probable cause to move your case forward. It's not a required or mandatory hearing. It's a hearing that you or your attorney decide that you wish to attend. At this hearing, you will not testify, you will not introduce evidence, nor will you call witnesses. The only thing you or your attorney may do is cross-examine someone who may testify against you. In Spartanburg County, you have up until the date of your initial appearance to request this preliminary hearing. Unlike your preliminary hearing, your date of initial appearance is a required or mandatory hearing. It is held at the Spartanburg County Courthouse located at 180 Magnolia Street. It is held on the second floor of the courthouse in a general sessions courtroom. The purpose of this hearing is to make sure that you have an attorney on record. On that date, if you have an attorney on record, you will sign in and you will sign out. If you do not have an attorney on record, you will sign in and you will remain there until you are excused by the circuit court judge, who will explain to you the importance of having an attorney in a general sessions court case. If you fail to appear at that date of initial appearance, that circuit court judge will issue a bench warrant for your arrest. You'll be brought back here and you will remain here until you are called for by that circuit court judge. if any of the charges that you have against you today are null pros, dismissed, anything other than you pleading guilty or being found guilty, you do have the right to have these charges expunged or removed from your record. Because of these are general sessions charges that we're looking at today, in order to do that, you'll have to contact the clerk of court, and there's usually a fee associated with that. Whether released on a personal recognizance bond or cash surety bond, you're released on what's called a condition of good conduct, which means once you're out, you must conduct yourself as a good citizen. If you get into any trouble, it could lead to what's called a bond revocation hearing. And that could lead to your bond being denied, a higher bond being set, or a bond with additional conditions being placed upon you. Some of your bonds may carry conditions today. If that's the case, you must abide by or adhere to those conditions at all times while you're out. If you fail to do so, it could lead to a bond revocation hearing or a contempt of court hearing. So make sure if conditions are set on your bonds that you follow those. I will caution you that anything you say in this arraignment can be used against you in court. Therefore, I'm going to ask that you do not discuss the particulars of your case. If you start discussing your case, I'm going to ask you to stop. I'm not being rude. We just don't want to have to testify against you. I'll also caution you that anything you say to another inmate or one of the officers, they can be subpoenaed to testify against you. If you are planning on asking for the services of a public defender, you must be indigent according to the federal guidelines. It means you cannot own a home or property. It means you cannot own any form of real estate or a private business. An example of the income that you can make if you're single with no dependents, you can make no more than $228 per week. When I call your name, I'm going to ask that you come up to the front of the court. Do not lean on the bench unless you're signing paperwork. When we are finished, you'll exit to my right, your left. You'll have a seat back in the pit unless the officer instructs you otherwise. Dennis Ray Alexander. Mr. Alexander, what do you plan to do about an attorney?
Right now.
All right. What I'm going to do is qualify you at the end of the arraignment. If that's okay with you, we'll get you qualified, okay?
Yes, sir.
All right. Mr. Alexander, charges facing you today are that you have a distribution, you're charged with the distribution of crack cocaine, possession with the intent. I must inform you that can carry 15 years in prison and or a fine of $25,000. You've been charged with attempted murder. I must inform you that can carry you up to 30 years in prison. You've been charged with possession of a weapon during a violent crime. I must inform you that can carry 5 years in prison. And you've also been charged with possession of a firearm by a convicted felon. I must also inform you that carries up to 5 years in prison. Before I set your bond, this is a formal bond hearing, and the purpose of that is let the solicitor make recommendations regarding your bond, okay? And at this point, we'll hear from the solicitor's office.
Thank you, Your Honor. I'm Jennifer Jordan, Assistant Solicitor with the 7th Circuit Solicitor's Office. Your Honor, we're here today, as you stated, on 4 warrants charging this defendant with incidences or 2 separate incidents. The first one is the distribution of crack cocaine with the alleged offense date of March the 5th of 2016. That is alleged to have occurred at on Harrison Street, as well as where the attempted murder and the possession of weapon charges come from. Your Honor, officers with the Woodruff Police Department were executing a search warrant in the early morning hours on Monday, March the 14th, 2016, when this defendant was in the back bedroom with a toddler in the back bedroom. When the officers came in, the defendant fired from the back bedroom and shot Officer Sergeant Darrell Dawkins in the left arm. He was shot, the bullet entered the front of his biceps and exited through the back of his triceps. Your Honor, we are asking in this case that based upon the defendant's prior record that dates back to 1997, starting with a possession of beer by a minor in 97, along with simple possession of marijuana in an open container, the 2000 resisting arrest, and a breach of trust, 2000, minor in possession of alcohol and giving false information. 2001, criminal domestic violence, first offense. 2002, criminal domestic violence of a high and aggravated nature. He actually was convicted of that charge in 2004. The 2002, criminal domestic violence, second offense. 2004, fraudulent check. He entered the Department of Corrections on the 6-month sentence for the previously mentioned criminal domestic violence, high and aggravated, in 2004. Your Honor, he has in 2005 an assault and battery of a high and aggravated conviction. He has from 2007 a fraudulent check. He has what appears to be in 2007 a violation of probation that landed him in this Department of Corrections. He has from 2010 a criminal domestic violence, third or subsequent. He has from 2014 a conviction for DUI, Your Honor. Your Honor, based upon the fact that the defendant by federal law is not even supposed to be in possession of a firearm, and he was in possession of a firearm even by his own admittance to law enforcement on the 14th, we believe that he's a danger to the community, that he's also a danger to himself, and we ask that his bond be denied.
Hi, Mr. Alexander. Under the charges you have, attempted murder falls under Section 16-1-60, which is considered a violent crime under the statutes of South Carolina. Based on your past history and based on this charge, the court is going to basically deny your bond to be set today. It will be set by a circuit court judge at a later date, okay? We do need to make sure that you understand that you do have the right to a preliminary hearing. You can either complete this now or you can wait and talk with your public defender about it. Which do you wish to do?
I'll talk to him.
All right, don't fold or bend it, okay? Because that's to be in good shape when it gets to the clerk of court. All right, you have a date of initial appearance of May the 19th, 2016 at 9 o'clock in the morning. Do you understand that? That's where you got to show up and say you have an attorney. If you understand that, take that pen and sign right there. Okay, hang on to that so that you can share that with your public defender and you're reminded of it as well, okay? This is everything we went over in the arraignment, everything that I went over with you. If you'll notice here, I have put that it falls under 16-160 and that your bond is to be set by in circuit court. So the only thing we need to do at this point is qualify you for your public defender, okay? You have any...
I just had one come back to talk to me and send it up.
Do I now?
I just had one come back to talk to me and send me up for the one.
They've already qualified you?
Yeah, he was just back to talk to me, back to talk him up.
So we don't need to do this here is what you're telling me?
Yeah,
What I'm going to do is put you're already qualified. If there's a problem, get on the kiosk and let me know, okay? And I'll make sure they come by and see you.
All right.
This is yours, okay? All right, thanks, sir.
All right, thank you.
Thank you, Your Honor.
Thank you. Do y'all wish to leave before we proceed with the rest of the bond arraignment?
Can you repeat the court date? I'm sorry.
There is no court date. What he has is a date of initial appearance on May the 19th,
Okay, thank you so much.
2016.